Let me note the presence of the accused, first accused, second accused, fourth accused, fifth accused, and sixth accused. And the victims, genuine reconciliation brings closure to the loss, however heinous the crime committed may have been. Reconciliation is even more critical where both the offenders and the victims were family, relatives, neighbors, or friends. It therefore behooves the courts, where the circumstances of a case permit, to promote reconciliation alongside penal sanctions. In my view, reconciliation speaks to the humanity of the offender and of the victims, while penal sanctions speak to society's condemnation of the offender and the offense, and the two ought to work in tandem. Close quote. It was clear that each accused was cast in positive light, having been lawful and a helpful member of their respective families and communities, with no danger or likelihood of committing any offense or harming anyone. These were positive attributes that go into reduction of the severity of sentence. Clearly, the accused do not deserve the maximum sentence provided for under Section 204 of the Penal Code. The prosecution has called upon the court to meet an appropriate sentence, while the victims have called for maximum penalty as the only way to find justice in their deep loss. The role of the court is to balance the scales of justice and issue an appropriate sentence, having taken into consideration the personal mitigating circumstances of each accused and the victim impact statement as required by law. Justice also demands that there be proportionality of punishment to the offense, and murder, no doubt, is a serious offense. Accused, I would factor in the period spent by the accused in pretrial custody as provided for by Section 333(2) of the Criminal Procedure Code, which obligates the court to take into account the time already served in custody. The accused spent an approximate 1 year in pretrial custody before they were either granted or met the bond conditions. They have also spent 2 months in post-conviction custody. This trial, as the record shows, has taken an unduly long time, owing to a combination of factors clearly reflected in the court record and already stated in the judgment. Although the accused were out on bond, the trial hung over their heads and must have caused them great anxiety. I have considered this a great mitigating factor which goes into reduction of sentence. In the end, I sentence each accused person: Paul Wainaina Boyo, first accused; Christopher Lumbasio Andika, second accused; Andrew Karanja Wainaina, third accused; Samuel Kuria Ngugi, fourth accused; Estan Dinda Mulingia, fifth accused; and Ruth Watai Irungu, sixth accused, to serve 15 years imprisonment. These sentences shall be deemed to run from the 19th of April 2024, being the date of their post-conviction custody. This is the ruling of the court delivered this 23rd of June 2024. Yes, thank you.
And I argue very respectfully on yes, Your Honor.
I should think that the proceedings that will be the post-judgment proceedings